Good afternoon, everyone. Welcome to the Steering Clear of Illegal Landmines Lessons for Landmen. We hope to provide you with information, insights, and advice to help you understand and mitigate risks in your practices. My name is Andrew Good. I'm a partner with 𝐓𝐢𝐦𝐞𝐬𝐬 in our Columbus, Ohio office. I've been practicing law for about 12 years now, and I focus on oil and gas litigation, commercial litigation, and construction litigation. Shout out to any fellow Buckeyes that may be on listening. I'm joined here today with my colleague, Joey Manning, who's a senior attorney in our Houston, Texas office. Joe, you want to tell them a little bit about yourself?
Yeah, I've been with 𝐓𝐢𝐦𝐞𝐬𝐬 for about 1.5 years now. Prior to that, I was a landman for 8 years with Range Resources most recently. I was an in-house landman and went to University of Texas at Austin for both undergrad and law school. So here's normally where I'd say a hook 'em or something like that, but yeah, the football team hasn't exactly been the greatest, so I'll just leave that out for now. And I mostly practice in our transactional area.
Great. So over the next hour, we plan to discuss a certain amount of things. So we'll hit on the importance of landmen, including their roles and duties, the applicable code of ethics, standards, and regulations, how they interplay between those, what are ethics, the different types of ethics, legislation and laws relating to registration for landmen in certain states, and the differences between personal, professional, legal ethics. We'll touch on legal and ethical landmines. That'll include the overview of the AAPL Code of Ethics and Standards of Conduct. We'll touch on within those honesty and fairness, fiduciary responsibilities, good faith and loyalty, confidentiality, conflicts of interest, communications, competence, cold drafting, criminal activity, harassment, discrimination, and the unauthorized practice of law. And then from there, we'll touch on what those ramifications would be for violations of. And then lastly, we'll present to you a few case studies and a bunch of hypotheticals, and then we'll kind of summarize the key points and tips. So it should be a fun one.
All right, so we'll start with importance of landmen. First, kind of the definition of landman. A landman is a public-facing side of an oil, gas, mineral, or other energy sources exploration and production team who interacts and negotiates directly with landowners to acquire leases for the exploration and development of minerals or other energy sources. As some of you know, in-house landmen tend to do things a little differently. You do negotiate with landowners somewhat, but you tend to be more on the business side of things, working with the other departments. You know, the geologists, the engineers, completions, all that side, regulatory and those things. Many landmen are also licensed lawyers. I was an example of that. I worked with many others that were. It's common. Pressures to perform are motivators and drive behavior. Obviously, if that can be one of those things where you need to get a well ready. You don't want to be the holdup. You're working with people, not rock, as we tell everyone. So getting a lease in time or a surface agreement, you're feeling the pressure to get those. And like I said, unfortunately, it's a moving target at times. But you still have to follow the ethical rules, and doing such is the key to success for you and the company. Some of those duties I just touched on: mineral rights acquisition or divestiture negotiations, due diligence projects, things of that nature, exploring and or developing minerals through business agreements. Sometimes that's negotiating JOAs, farm outs, AMIs, similar types of agreements. Researching public and private records to determine mineral ownership and title review. So running title. That's probably the most common one that if you're a landman, you need to be the most well-versed in, as that's going to be 90% of your work, especially out in the field. But even in-house, there's a lot of times where you need to be able to do the work yourself and run the title yourself. And that's a key area. That's a key duty, I should say. So ethics and professional organizations. Landmen are not per se regulated by any state or federal agency, meaning there is no state or federal governing body that issues licenses or certifications. Many landmen choose to become members of professional organizations. The AAPL is the big example of that. And some of these organizations do, however, issue certifications. For example, the AAPL will issue the RL, the RPL, and the CPL based on the years of experience in that in the landman industry. Those are regulated, and there's testing involved in order to qualify for those. There's NADOA and NALTA, which if any of you are division order analysts or were before, you're probably a member of NADOA, same for lease analysts. These organizations, along with personal and legal ethics, help maintain and promote integrity, develop trust, and avoid ethical legal risks. The AAPL has a standard of conduct which they want you to adhere to. So that's an example of trying to help avoid ethical and legal risks. If you follow their code of conduct, you're going to tend to avoid those risks.
What about ethics, right? These are really the foundation of your conduct, the business principles that you operate under or your company operates under, and they're the ideals that you adhere to in the professional world. There's three types of ethics: professional, personal, and legal ethics. And we'll touch on those each in the next couple slides. So why are these important? Well, they set the standard for your behaviors and actions. It allows you to develop integrity, creates credibility in the industry, instills trust not only in your peers, but your employer and those that you're working with. It improves your decision-making capabilities, guides you to make the right decisions in tough situations or easy situations. It protects yourself and your company. And in doing that, it provides you some defenses or advantages in business. So professional ethics, right, as Joey touched on, these are really the ethical principles or standards implemented by the professional organizations or by your companies. Joey touched on the AAPL. There's also the National Association of Division Order Analysts, the National Association of Lease and Title Analysts. Each one of these has their own ethical standards and code of ethics that if you are a member of, you have to adhere to. So for instance, the AAPL, members, you're committing to the highest ethical standards as outlined by their code of ethics and standards of practices. Similar to that, the other two really mirror those, and you need to adhere to those, otherwise you face issues not only with your certification or the ability to work, but also protecting your reputation and avoiding liability. So personal ethics. These are your ethical principles and standards that you use to judge behavior as right or wrong in both personal and professional settings. In other words, these are really your personal beliefs about what are right and wrong. These are guidelines for the decisions made both in and out of the workplace, including how you handle certain situations. And these play an important part on how you grow and you develop in your career and have an impact on your reputation. Examples of these: honesty, loyalty, integrity, respect, responsibility, selflessness. And why are personal ethics important? Well, they allow you to be more effective. You're not worrying about going down the wrong path with a decision. It follows along with your reputation and instills trust and support from others. It provides you that foundation as you are either starting or continuing throughout your career. Improves obviously decision-making process and capabilities, and it sets the standard of your behavior and how you're going to conduct yourself in both professional and personal world. So legal ethics. These are the codes of professional responsibility that set forth the generally accepted standards of conduct. Think of these not only as those model codes, but also as laws and regulations. As Joey mentioned, many landmen are licensed lawyers, so a balanced approach must be applied when a lawyer is working as a landman and vice versa. For instance, the overarching kind of rules that mirror most states is the American Bar Association's model rules of professional conduct, and each state, as outlined on the PowerPoint, has specific models. Most of them mirror the ABA, but some are different depending on the state. So then we're going into legislation, and I mentioned this earlier. So while many states have attempted to pass legislation that would require licensing requirements for landmen, there is none at this time other than some registration requirements. And with that, the first one that we'll look at is really in Ohio, me being from Ohio. So the Ohio Supreme Court in a case called Dundics versus Erie Petroleum Corporation, which was in 2018, they basically held that independent oil and gas landmen were facing civil and criminal penalties if they continued to negotiate oil and gas leases without first acquiring a real estate broker's license. A few months later, the former governor of Ohio signed into law Senate Bill 263, which went into effect in March of 2019. This amended the revised code section 4735 to specifically exclude oil and gas land professionals from having to be licensed as real estate broker to negotiate oil and gas leases in Ohio. However, when looking at whether or not someone could engage in fee transactions, the statute essentially fully exempts in-house or employee landman, but for field or independent landman, they're prohibited from engaging in those and must comply with due disclosure requirements in order to be exempt. Now, those conditions that must be applied is you have to register and pay the annual fee, which I believe is $100. You have to maintain a membership in a professional organization that sets forth performance and ethical standards such as the AAPL. And then you have to provide certain disclosures, written disclosures to landowners on forms approved by the superintendent. And so North Carolina and Maryland, they have a similar, but they actually require a landman to be registered in order to be a landman. So for North Carolina, if you're not registered, you could have your license or your ability and your certification revoked, and you could also incur civil penalties. For Maryland, it's required for those who negotiate with owners for the acquisition of mineral rights in oil and gas. So it must be, the registration has to be presented to the property owners before doing anything, negotiating. And while the statute is unclear as to whether or not there will actually be penalties, there is a potential for fines and civil penalties moving forward. I was unable to find any type of instances where a landman has been subject to penalties at this time, but it's something just to be aware of if you are doing any of this work in Maryland. So looking at the differences between all three. So personal, obviously it's your beliefs, your values, it's your moral code or your personal conscience. So an example I'll talk about between all three of these is you're returning a lost wallet to somebody versus keeping it, right? You're maintaining honesty, you're not going to steal. Professional, it's your personal values in the workplace. It's a set code of conduct that must be adhered to. You're returning the lost wallet to a coworker versus keeping it. So no theft, no stealing. In the legal, avoid consequences. So criminal and civil liability are issues. These are the legal limits that you can operate under. And another example is returning the lost wallet versus keeping it. So you're avoiding theft. You're avoiding any criminal issues. So they all interplay together, but you have to understand what your own personal ethics are and apply them to the professional and then understand the legal.
Okay, and I will jump in here for the ethical and legal landmines. So we'll start with the AAPL Code of Ethics and Standards of Conduct. The Code of Ethics, well, it's a Code of Ethics. It shall be the basis of conduct, business principles, and ideals for members of the AAPL. If you don't follow those, it's considered unethical, and the individual's membership status shall be subject to review for possible disciplinary action as prescribed in those bylaws. The Code of Ethics was established to inspire and maintain a high standard of professional conduct for the members of the AAPL. So it lists out the summary of each of these. The first being fair and honest dealing with landowners, industry associates, and the general public to preserve the integrity of the profession. The next, adherence to a high standard in conduct and fulfilling his fiduciary duties to a principal, avoiding business activity which may conflict with the interest of his employer or client or result in the unauthorized disclosure or misuse of confidential information. An example of that being, say you're working for another operator and you worked for a previous one in the same area, and you were telling them what the other one was paying as a lease bonus, trying to use whatever information you had or any geological information that you might have to, maybe either to get yourself more business with the new one or, making yourself more important, I suppose. So you don't want to do things like that. The next, performance of professional services in a competent manner. So we'll discuss this a little bit more later, but don't hold yourself out to be competent or knowledgeable in all areas, all states, all counties or parishes. when you're not actually competent in those areas. Yeah, it can get you business now, but it's going to cost you later, especially if you don't understand the differences in the standards between each of those states or locations. You're going to get lost and you're going to provide a bad work product. Adherence to any of the provisions of the bylaws, code of ethics, or any rule that's pursuant to those bylaws. Avoiding the aiding and abetting of any unauthorized use of the title certified professional landman, registered professional landman. So if you see somebody out there using CPL at the end of their name and you know they're not a CPL, might be a good thing to bring up. And avoiding any act or conduct which causes disrespect for or lack of confidence in the member to act professionally. So if people think you're not professional, not a great thing, so don't act in a way that's unprofessional. Honesty and fairness. So at all times, the land professional has a duty to promote and in a fair and honest manner represent the industry to the public with the view of establishing goodwill. Conduct yourself in a manner consistent with fairness and honesty to maintain the respect of the public and protect those you deal with against fraud, misrepresentation, and unethical practices. An example of that would be going to try to get a lease from a landowner and they're tough, they want more money than you want to give or the company wants to pay, and saying that, well, without this lease, the company's not going to drill it, so you better sign the lease or you're going to get nothing, especially if you know that's not the case. So you don't want to try to press someone into doing something they don't want to. In doing so, in acting honest and fair, you should eliminate actions or practices that are damaging to the public or discredit the industry, and conduct business in a professional manner that is fair, honest, and respectful to the industry and public. So, and hopefully that falls in line with your personal ethics as well.
So fiduciary responsibilities, we have 6 listed up here, depending on your state. You know, there may be others, but the first one is trust, right? So, and what I mean by that is a landman shall ensure that the monies coming into his or her possession are in trust for other persons. Examples are escrows, advances, etc. And you need to make sure that those are A, properly accounted for, and B, administered in a manner approved by your employer or the client. So you also have a responsibility to protect. So you have to protect the members of the public with whom you deal with, and you want to protect them, as Joey mentioned, from fraud, misrepresentation, and unethical practices. Fraud and misrepresentation are one and the same in most states. It's either a misrepresentation of a fact or a withholding of a fact that should have been told, and that essentially is causing a different scenario to play out versus what could have happened if the truth or the accurate facts would have been presented to them. So, you know, there's a gray line between what you're saying, but you also have to, you know, make sure that you are representing accurate facts. If you don't have those accurate facts, then make sure you get them before you present them. Eliminate practices. So eliminate any practices that are damaging to the public, right? Or bring discredit to the industry. Those are your actions, not only in the professional workplace, but also out in the public. If people know that you are a landman, you're operating, and you're going out and you're doing things that could perceive you to be unethical or unprofessional, those types of things can lead to issues. Fairness. So you're going to treat all parties to a transaction fairly and act in an ethical manner, right? So disclosing a set of facts to one landowner versus another landowner in negotiations would not be fair. It also would be dishonest. And then competition, we all know that the industry is highly competitive, but it needs to be kept at a high level with a careful adherence to the established rules. Make sure you're always operating in a fair, honest manner. And just a real caveat is, maintain courtesy with all parties. Things can get heated, but acting professional and acting courtesy goes a long way. Compensation. So a landman cannot accept compensation from more than one client for providing the same service, or accept compensation from another party to a transaction. So, but you can only do that if the parties to the transaction have full knowledge of it, and I would recommend getting that knowledge in writing and signed by all parties. So good faith, loyalty, and confidentiality. So you need to act in good faith in dealing with industry associates, clients, competitors. And what good faith means is it's a sincere intention to be honest, fair, lawful, and it's without any malice or desire to defraud or take advantage of others. And so in doing so, you need to avoid unauthorized disclosures or misuse of confidential information, both for professional or personal gain. You're not going to aid or abet, much like Joey said, in the unauthorized use of a CPL, RPL certification or any other type of certification that is governed by a body that has rules. Conflicts of interest. So through this, a landman, needs to avoid business activities that may conflict with the interests of his employer or a client, disclose his interest in an area that may be in conflict with a principal, employer, or client, not act adversely or engage in an enterprise in conflict, reveal facts of his ownership in a property or interest to a potential buyer. And we'll get into, there's an example of this later on. And then obviously not acquire anything for yourself or others in terms of an interest in property, where you're called upon by your principal, employer, or client to go after. Don't undertake any professional services on your own behalf concerning property that you may have a conflict of interest in, or your employer may be interested in. Always be aware, understand, double check before engaging in any personal services or interests, because it can obviously lead to issues that will not only harm your reputation, but the ability to be employed and get paid. And so the last one really is, don't accept any compensation from more than one principal for providing the same service, or accepting compensation from one party to a transaction without your employer's knowledge and consent. And again, I recommend getting that consent in writing and signed by all the parties, just to make sure that no one comes back at the end and says, we never approved it. And then it's a he said versus she said, or he said versus he said.
Yeah, and to jump in real quick on the conflicts of interest, one thing you'll see sometimes, and hopefully not very often, is as a landman, you're privy to information from the operator about when they're leasing, where they're looking to lease, where they may drill, and every now and then someone will have a family member go buy some land beforehand to try to make some money off of that, and as you can imagine, that would be a conflict of interest and unethical.
So next we have communications. So to me, communications are extremely key. They can also be double-edged sword, expose you to problems. So effective communication, not only with your team, with the client, the competitors, the landowner, is a key factor in success for any project. And in doing so, there's some things that you need to be mindful of. So don't misrepresent any material fact. Don't try to induce another tender into a contract with false statements or things that can be considered to be inaccurate. And that's that can take place easily through natural conversation with people, especially as salesmen, through sales talk and puffing and grabbing estimates and giving opinions that may not be factual or may not end up being factual down the road. You need to make affirmative disclosures, and so that's the opposite, right? Things that things that are affirmed, you can provide those. If you've already made any false, deceptive, misleading, or that gray line, correct them. If you have the information to correct them, and that the information you have in your hand is factual, correct them, because it's only going to avoid issues down the line. And you need to also present any type of accurate representation in terms of advertising or disclosure to the public your capacity as working as a landman. So if you don't do those things, right, and communications, much like everybody, and the words that you use can be interpreted multiple different ways, and that's why Joey and I likely have jobs, because everybody hears things differently and they can perceive things differently. And so if you're not communicating in accordance with the rules, your professional ethics, the legal ethics, then the end result can be the landowner can sue to set aside lease. They can sue you, your client, your employer, for misrepresentation, fraud, breach of contract. And depending on your role, the company you're working for will likely be also liable for those misrepresentations and can be bound by your actions. So Communication is key, and I know everybody wants to make sales and wants to get these things done, but balancing those things and knowing when, how, and why to speak is really, really important. From a litigation standpoint, this happens in every case. Somebody perceives something differently, or someone just supposedly remembers something, and then it's I never said that, no, he or she said that, and we're off to the races. And I would recommend that if there's the possibility of documenting conversations, and it doesn't have to be everything, but in your own perception, if there's something important that an owner or somebody that you're negotiating with has, jot that down, date it, keep it, or get it to the right person, get it to your legal team if they need to be aware, escalate it to whoever so that certain actions can be made, or they can be documented, put in a file, in lieu of maybe potential some sort of legal action down the road. Also, that documentation could save you down the road from having a complaint filed against you with the professional organization. You can then have a documentation to say, on this day, this person said this, I never said that, and here's why. And that goes a long way because you have physical evidence of that. And so, with all of this, right, you as landman and land professionals, you're most of the time the first person that will interact with the landowner. And how a landowner reacts to you goes a long way in determining what the end result will be. So, the AAPL, they have techniques that recommend in terms of communication. One is speaking the landowner's language, right? Don't talk over their head, that's so they can't understand it. Open with an offer. Know your target price and your limits. Don't anchor low. Try not to be adversarial. My favorite is learn to love silence. And the reason why is everybody has an innate ability that when you're talking, they don't like silence. So if you're quiet, that individual is likely to keep talking. It's better off for you because as they're talking, you learn more about them, you learn about their pressure points. It's only going to make it your ability to get the deal done. Be prepared with a counter offer and never rush it, right? Because rushing can also lead to problems. Also, be prepared to answer questions. As most of you know, I'm sure you get a lot of questions that may not seem important to you, but they're very important to landowners. And those need to be addressed before an owner is willing to consider selling or leasing. Specifics, some examples of those. What specific rights will they have, and what rights will we have? What is the overall process going to look like? How long will it take before they start receiving royalties? How did the offer come about? Explain to them the background of that. Who do they contact if they have questions? Is it you or is it somebody else? Is it somebody in legal? What are the responsibilities that the company has? And how do they know if you're accurately reporting the quantity of material or minerals that they're being compensated for? Those are just a few examples that I've found that seem pertinent, and maybe everybody's shaking their heads if I could see everybody, but communication to me is very, very key. And then also the next slide we'll go to, I think, is also very key. Competence and expertise.
Yeah, and on that one, a landman shall keep informed regarding laws, legislation, regulations, public policies, and market conditions in the area of represented expertise so that you can properly advise your client. You need to represent others in your area of expertise and shall not represent yourself to be skilled in professional areas which you're not competent or professionally qualified. As we discussed earlier, you don't want to hold yourself out to be knowledgeable everywhere if that's not the case, because again, it may get you business now, but it's going to cost you business later, and you could face legal consequences as well. So that's something that's a big problem. A lot of times somebody will say, yeah, I got it. I have this many years of experience in state A, or let's say Texas, and I can do Louisiana work, and they get there and they pull all the wrong documents and don't know exactly what they're looking for because it's very different. So don't hold yourself out to be competent where you're not. Sometimes, though, you'll face a question that is beyond your level of competency, that's out of your control. And when that happens, it's better to get clarification now rather than guess what you should do and provide either bad work product or just give the wrong answer altogether. And again, you can be liable for some of those wrong answers. A lawyer, landman's failure to admit when an issue is outside their competency directly violates the professional codes and can lead to devastating consequences for the client and yourself as well. That's something to be mindful of.
Yeah, before you jump in here. So I said, obviously, this is a part of, to me, as a litigator, one of the most important things that everybody needs to be adhere to and be mindful of when they're out there, because it does play a part in with communications. So in my world, right, questions we ask is if you're not 100%, certain of something, then it's, you can't say for certain, right? It could have been either or, it could have been something else. So a rule of thumb is if you're facing a problem or a question that is beyond your level of comfort or competency, and that can be for people that are still even competent in an area, but maybe the question is difficult, or maybe you don't have the answer right in front of you, right? Much like the rule of thumb in construction or something else will be is measure twice, cut once, right? It's the same thing. Don't just blurt out an answer until you know for certain, because in the end, if it wasn't a certainty or it wasn't confirmed or it wasn't a fact, right, it can be construed and manipulated down the road to make you look like you were misrepresenting or trying to close the deal based on false facts. So this is it's another key one that ties into all the ethical standards that we're reviewing for you today. So cold drafting. I asked Joey if he knew what cold drafting was. I think this might be something I found that I can trump him on, but essentially what cold drafting is when a landman quickly extends an offer without really doing any due diligence in order to get a lease signed, right? And that's based upon what he or she thinks will get it done. So there's parameters that you're operating in, you do it quickly, you don't do your due diligence. And then with that, the company you're working for is essentially understand or condoning these actions, right? And what the benefit for them is they're buying time to verify ownership and figure out exactly what leases they want to move forward with. And then once that is done, the company essentially defunds or closes the lease purchase accounts and refuses payments on the drafts. And so then you as the landman are left with your hands open to clean up the mess. You're made to look bad, you're made to look untruthful, and more likely than not, it's going to end up in litigation that's going to drown out, it's going to take you away from your wife, your spouse, your kids, your professional career, and your personal life.
Cooperation, criminal activity, and harassment. This is kind of a little bit common sense, but the industry has issues with this occasionally, so it is something to touch on. The AAPL requires anyone charged with unethical conduct or that's asked to give evidence in an investigation, they must give all the pertinent facts before the appropriate authority of the AAPL. So it cooperates any investigation of someone that's being accused of being unethical or doing something that's against the AAPL's code. A landman shall avoid any conduct which causes disrespect for or lack of confidence in the member to act professionally as a land professional, and this obviously includes harassment, bias, and discrimination. And then the next one, don't commit a felony or any other serious crime. Not only is that bad for you individually and as a part of the public, it's not good for you as a landman either. And don't deny any services to a person because of reasons of race, creed, sex, or country, national origin. The AAPL has a zero tolerance policy on these things, including harassment, and you can lose your certification. But of even more concern is that those actions are damaging to the victim and can subject you as a landman or your employer to severe civil and criminal penalties. So again, this is kind of a simple thing that we teach children: treat others as you would like to be treated. It needs to be brought up because you do hear about it from time to time. So keep that in mind.
Again, for this one, it comes back to communication. What you may say or do may, in your mind, be a joke, maybe harmless, those types of things, but everybody else is different, right? So everybody perceives actions, conduct, words differently. And so that's why in terms of this, you may say something that you don't even understand to be discriminatory or harassment or anything like that, but that person may perceive it to be. So you have to be mindful in your communications, because this is a serious one. It's between harassment and discrimination, it can lead to criminal actions. It can also lead to civil liability, and more likely than not, loss of employment and those types of things, black X on your reputation, and a whole host of issues moving forward.
Yeah, and it's not okay. You hear it a lot of particularly females in the industry go, well, it happens. It's it's the old boys club. It is how it is. No, it shouldn't be that way, and it's not supposed to be that way. So speak up when those things come about.
So the unauthorized practice of law. So Joey at the beginning had indicated that there are landmen that also are lawyers, licensed lawyers. And so while the normal or usual job functions of a landman are generally excluded from the unauthorized practice of law in most states, you have to be cautious when rendering any type of advice or guidance that can be perceived to be in the legal realm, right? One of those things, and obviously an issue is if you're operating as a landman, you're a licensed attorney, you provide some sort of legal opinion or advice, and you don't have malpractice insurance for yourself, and you're not going to have it through your employer, that you're exposing yourself to personal liability for malpractice. So that's on the civil realm, but also your licensure. And so, you need to consider special restrictions on whether or not you should hold yourself out as a lawyer, because you're subject to the applicable disciplinary rules if you do so. And so, for instance, Rule 8.4C of the ABA rules says that it's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. That's just wonderful, right? So if you operate like that as a landman, but you also operate like that and you're a licensed lawyer, bar associations can find out and they could pursue, or somebody could file a complaint against you, and then you're being investigated, potentially to lose your legal license that you worked really hard for and had to pass the ridiculous bar exam. And within your job duties, right, some of those things that Joey mentioned, the interpretation and preparation of legal documents and reports, you have to understand the complexities of mineral law and contract law. Yet you're involved in negotiations for the rights. All of these things can constitute the unlicensed practice of law, depending on how it's operated, depending on your conduct, depending on your communication and what you're saying. So be mindful of that, because it is if you are subject to this and you're being investigated, it's public record, and from there, it's a black eye on top of all the other issues and problems and penalties that you're going to face. So what are the ramifications, right? I've been mentioning a bunch of these. So landmen that are lawyers are subject to the disciplinary authority of the states that they're licensed to practice in. Any landman misconduct, if you're a member of the AAPL, it's referred to the AAPL Ethics Committee, which they will review those, they will make a decision, and then they will send that to the board, who makes the finalized decision on whether or not any disciplinary action would be applied to you. And then they uphold those standards in moving forward, and they publicize them a lot of time in certain publications. So of all the things that we talked about, right, most of these things are common sense. You see them, you know them, you probably get training internally, you probably go to webinars similar to this, you hear them consistently, but applying them to your everyday practice is really key, because if you don't and you're found to violate them, you can be expelled or suspended from the AAPL. So if you work in Ohio and you're suspended or expelled from there, well, now you have issues with the registration. You can be censored by the AAPL. you're going to lose credibility and harm your reputation. You could likely lose your employment or not be able to find employment. You can be reprimanded, punished, disbarred from the practice of law. And then there's the overarching big one, which is exposure to civil or criminal liability. These are all headaches that everybody wants to avoid, but obviously the common sense approach and reviewing these as a refresher every now and then is a recommendation. So some case studies and hypotheticals kind of close the loop of what we've been saying. This is a Texas case from 2012. Company contracted with a land brokerage firm to acquire some oil and gas leases in East Texas. Within that agreement, there was a non-compete clause. The leases were acquired in the landman broker's name. They were assigned to the client upon meeting this target client's attention. However, during this time, that same landman was working for other associated entities of the company, his company, to acquire leases in the same area. Well, what happened is the client ended up suing the landman for breach of the non-compete clause and other various torts, including fraud and misrepresentation. So landman, obviously, through these associated entities that were not part of the deal with the company, filed some motions to basically stop the case and have judgment ruled in his favor. That went that way with the trial court. It granted it. It was appealed. The appellate court held that the associated entity was not personally liable under the contract because it wasn't a party to the contract. So there's no non-compete with that associated entity. However, the court held that the landman broker himself had a duty to act solely for the benefit of the client because the landman broker had proceeded to acquire leases on behalf of the other client. And so they found that the non-compete was breached, and that landman was also reported to the AAPL, I believe it was, for a complaint for doing this. It was a conflict of interest. It was also dishonest, and there were misrepresentations. And that's a real case.
All right. Well, this one isn't against the landman themselves, but it's how landman played an integral part in the case. This is a recent one out of Louisiana that made its way up to the Fifth Circuit that actually played a big part in what we do here and how we look at things. An unleased owner in Louisiana filed suit against an operator due to the operator not providing disclosures and reports as required under Louisiana's conservation laws. The operator argued that the letter they sent, that the landowner sent requesting for that information, was too vague. They then argued that their senior landman was confused as to what was requested. However, that landman under oath inferred that he knew enough about the landowner, the statute, and the information to be provided under the statute that any confusion he purportedly had as to what information was being sought was not a defense. So what he said kind of went against, the court essentially said, yeah, you claimed you were confused, but obviously you know enough that that couldn't have been the case. And the court also stated that the declaration by the landman corroborated that he and the operator were reasonably competent mineral operators and must have known what information was being requested and what was required under the statute. So again, it's not just you as a landman that you have to worry about yourself individually. It's what you say and do. What you say and do can also affect your company. So this is more towards in-house landmen. So be careful with what you say and how you convey information to landowners, because that information can, and as you can see, was used against him, against his company in court, and the operator lost because of that.
This is a real ethics violation through the AAPL. I've changed the names just because I didn't know if anybody would know this individual, and I didn't want to embarrass anybody. So essentially, Jim Landman was an employee of Smith Land Services and performed some land work for Lots of Cash, Inc. You know, as he conducted his research and title work on behalf of Lots of Cash, he gained considerable knowledge of an Ohio unit. He used that confidential information to try to persuade other landowners in Ohio to sell that unit and sell the mineral rights to him instead of leasing those rights to his client. When the landowner agreed to sell the rights, Jim Landman used his significant other's name for the official paperwork, trying to cover his tracks. but he left a paper trail, including his own letters as well as county deed record filings, and he was eventually caught. So what happened? Well, a complaint was filed with the AAPL, and pursuant to their code of ethics under Section 2, land professional should not portray his partner's, employer, or client's trust by directly turning confidential information into personal gain. And the land professional shall exercise the utmost good faith and loyalty to his employee or client, shall not act adversely or engage in any enterprise in conflict with the interest of his employer or the client. So what Jim Landman did is he portrayed Smith Land Services and the client, Lots of Cash, by clearly engaging in activities that were in conflict with the interest of his employer and the client. He was found to have violated that section. He was expelled as an AAPU member, and that also included his loss designation as a CPL. So another hypothetical we put together. So Landman is both the CPL and licensed attorney. His employer directs him to negotiate with the owner to obtain a lease. Landowner knows the landowner will agree to a deal that's favorable to the company and that other companies are interested in the same property. So can a landman push for a bargain when nearby owners are getting something better? Probably not as the landman. Why? Because if the owner later found out that he was getting less than the going rate, he'd be angry, upset. These actions would be construed as not holding the industry in the best light, which is a primary ethical duty under the AAPL. More likely than not, that person is going to say that there was misrepresentations or you were not being forthright, which goes not only to dishonesty, but some of your fiduciary duties. And then it also exposes you to liability. And mind you, so for instance, in Ohio, misrepresentation, fraud, there's a 4-year statute of limitations. And what that means is if it happens today, right, from this date that it occurs, that individual or that company has 4 years to file a lawsuit against you. Now, every state is different, but these things can pop up much further down the road once things develop. So you have to be cognizant of these things. And then the second kind of question is, could the landman state or imply that there's an opportunity, that the opportunity is the owner's only hope as part of the negotiation, right? No. This is a clear ethical violation. It equates to dishonest conduct. The landman has to tell the owner that there's others interested under the code. Next hypothetical. So landman works for company X and identifies prospective properties. The landman is then fired. So can the landman go work for company Z working in the same geographic area? Well, no. The thought that the landman would not use confidential information previously learned, so unlikely that's ignored as a possibility. Likewise, you probably want to, if you have a contract with your employer, or if you're an independent contractor and you have a contract, you want to see if there's a non-compete, non-solicitation, confidentiality agreement, and adhere to those because they are enforced and enforceable in most states. And going to work for another company in the same geographic area is considered an ethical violation unless a reasonable amount of time has passed. And sometimes, these types of things more so are related to the confidential information or training or things like that you're getting from the employer that you know. So be mindful of that. So the flip side, well, what if you go work for yourself? Well, no, this would be self-dealing because you've gotten all this information, you were paid to find these prospective properties, and now you're taking that information, you're signing yourself up, and you're going to use that. That's self-dealing, problem with that, and you can get in trouble.
Another hypothetical, landman is a licensed lawyer in Ohio, but unlicensed in Texas. He holds himself out to the public in Texas as a lawyer. Is this an ethical violation? Yeah, this is, violates the code. Remember, you cannot act fraudulently. Likewise, violates ABA Rule 8.4. And something for in-house landmen to consider is if you're not functioning as an attorney for the company, don't put things in your email signature. You don't see it a lot, but it's there every now and then. Don't put JD or something. The rarely seen Esquire. Don't put that in your signature unless you're an attorney for that company. Another hypothetical, now this one is rather common. Landman bills a client all day, yet only worked 4 hours. Of course, that's an ethical violation. A lot of the times the thought there is that the typical landman would take a day, so I'll bill what a typical landman would bill despite it taking me less time. No, you can't do that, shouldn't do that. Only bill what you actually worked. likewise, there's no double billing. You can't, it shouldn't happen anyways, but don't do it. You shouldn't be working in the same area for 2 different clients. So that really shouldn't be a problem, but again, don't try to double dip.
So what happens when you learn of a business opportunity that is advantageous to you, where the prospective buyer needs capital, and you have capital, you offer that prospective buyer capital? Is that an ethical violation? Yes, because you're prohibited from getting involved as a professional in property or transactions in which you have an actual or contemplated interest, unless, as we said before, it's fully disclosed to all affected parties. And again, it's fully disclosed, and make sure that's in writing and make sure you get their consent to those things. As a lawyer as well, yes, it's a violation. ABA Rule 1.8 prohibits lawyers from getting involved with business transactions with clients without certain conditions being met. So lastly, Landman's going through a nasty divorce. She decides then to post defamatory statements on social media, posts a private video online. Is this an ethical violation? Yes, it is. AAPL requires ethical standards even in non-Landman related conduct, right? So your personal actions can carry over into your professional no matter what. And that's the same for lawyers, same for most professionals. So key points and lessons that I see are: know your rules, know the codes, check your ethics, right? Tell yourself it before you're going to speak with somebody every time. Know your responsibilities and duties. If you don't have a clear understanding of your responsibilities, your duties, or the parameters around those things, make sure you're asking either your employer or going back and looking at your contract that maybe you signed that outlines those. Communication is absolutely key. I can't emphasize this enough. It's the way people perceive things can be construed. People forget things. People don't always remember that they've said things when they have actually said them. So it's very, very important. No misrepresentations, right? So in terms of your sales talk and you're trying to get the deal done, don't go down that silver or gray line where it could be, go one way versus the other. Use facts, use affirmative disclosures. And if you don't know, right, then ask. Get the information, get concrete from those that can provide that information to you, and then you can use it. So I mentioned previously, avoid some deceitful sales tactics. So cold drafting is one of them, puffing. There's a whole variety of them that can compel individuals that are definitely not going to be knowledgeable of the things that you're saying, especially the first time you approach them. So try to be honest and as clear as possible with what you're trying to say. Avoid conflicts or understand conflicts. If you have property, if you own property in certain areas where there might be some landmen coming around, or it's perceived maybe coming down, make sure you have that information and know it so you can disclose it to individuals or potential clients. Keep everything confidential. So things that you learn from your employer, things that you learn from your client, keep those close to the chest and don't disclose them. Don't use them for personal gain, because in the end, that's just going to expose you for a liability and a headache, and it's going to tarnish your reputation. So with that, that's the key points. Thank you. Thank everybody for coming. Again, if you guys are out at the AAPL annual conference, would love to meet you and stop by for the happy hour on Thursday.
Yeah, and if you have any questions, feel free to email us and we'll reply with an answer.